Please, my ladies and my lord, I appear with Mr Henderson on behalf of the appellant, and then friend Mr Irwin appears on behalf of the Secretary of State responding to the appeal. I hope that the court has received all the relevant paperwork. There were some replacements in recent days, but I think I can take it for granted that the court does have them unless we resolve the problem as we go.
Yes.
There is, as the court knows, a video link for Mr Clarke who appears on the screen.
Mr Clarke, can you see and hear us?
Yes, ma'am.
Good. Thank you very much. Do let us know if there's any difficulty or if the connection breaks and we haven't realised it.
Okay, ma'am. Thank you.
Thank you. My lady, my lord, there is, of course, 3 grounds of appeal.
Just before you launch in, Mr Earl, if I can just tell you that we've had an opportunity of reading into the case extensively. So we've read, obviously, the judgments and the skeleton arguments, and we have read and are familiar with the relevant authorities. So,
very grateful. My lady, if I appear to be taking you to something which is not going to assist the court, please do move me along. But I bear in mind already that helpful indication.
No, well, it seemed to us that whilst there are many, many grounds of appeal, the main issue, certainly, which Lord Justice Phillips was concerned about, was the issue of an oral hearing.
Yes, and indeed the particular way in which one interprets or applies the policy as it relates to a dispute of issues, where that may be factual or where that may be experts who have reached differing views on matters of relevance. Within that structure, the 3 heads, as it were, that cover the more numerous grounds concern the oral hearing question, as my lady has rightly pointed out to me. Whether that is applicable with policy or the requirements of the common law to have proceeded without such an oral hearing in the circumstances of this case. The other element, which was set out as grounds 1 and 2, concerns the ability to put in written representations following the decision of the local advisory panel to provide a recommendation and a report, which would be considered by the ultimate decision maker, the Secretary of State's CART team, if I can call it that, the Category A Review Team. This is a case in which we raise again the common law procedural fairness principles, and also the policy question arises as to whether or not there is in fact a implied entitlement or an express entitlement under the policy to have the opportunity to provide that written representation. It may, of course, also inform and go along with the benefits of an oral hearing in a certain case where there isn't that opportunity. But you'll have seen there is some element of the grounds dealing with that question, and it may be of some importance because there is a fundamental principle point between the parties on interpretation of policy, which I'll come to when I deal with those grounds. They won't take up the majority of the court's time, but I think that there's certainly an issue between us as to the way in which those policies apply and are to be applied, this PSI and also others. And the 3rd heading of the grounds really is the learned judge erred. We respectfully submit on the facts in not finding in favour of the requirement for an oral hearing.
So what's the test, Mr. Rule, that we should apply in deciding whether or not we should intervene? Is it just whether or not the judge is wrong?
Yes.
And then there's a subsidiary question. Would you accept that the question for the judge was whether or not the CART was wrong not to have an oral hearing in this case?
My lady, that's the terminology that Downs uses, called a bill in Downs.
Yeah.
I would express it differently, although to the same effect. I would use the expression in Mackay or in Osborne that it is a matter for the court to decide whether, in the circumstances of the case, common law fairness required an oral hearing to occur. And the reason I prefer the formulation from those cases, although I say they are to the same effect, is they avoid any risk that the judge considers that the reasonableness of CART's decision or a review of CART's reasoning or decision is the question before the judge. Of course, the judge will take into account the reasoning and take into account CART's decision, but the question for the judge is simply whether in all the circumstances fairness required an oral hearing. And it's better not to talk about the reasonableness or error or not of the Clarke decision to ensure that primary function isn't lost.
Thank you.
My ladies, my lord, there is one update to the position as it stands in the papers, which the court will already have noted that the procedural history of the case is that the judicial review was decided when there had been another Category A review decision.
Yes.
There had been an application to amend which wasn't allowed, but as a result of that judgment and the parties' agreement, nothing had changed with the new review. So we carried on with the judicial review on the already once replaced decision. That decision was then replaced again in 2023, and there is an outstanding judicial review which has been granted permission in relation to that, which you'll have seen reference to in the skeleton argument. That is not listed at present and will obviously need to be reviewed once we have the benefit of this court's judgment on the previous Category A decision. Added to that, and this is perhaps not surprising because we see it happened in Hassett and in Mackay, that by the time the appeal is dealt with, there has been at least one further decision, if not more. There is yet another decision. We were informed on Monday by the respondent that there was a decision taken on the 5th of June. In the usual way, those decisions are not immediately promulgated, but take a month before they're sent out. So at this stage, it hasn't been promulgated, it hasn't been sent out, but we were informed of its fact, that it has been taken. And to this extent, we know that it doesn't change matters in that it was negative on categorisation and negative on oral hearing.
So effectively, there's been 2 more annual, if I can call them, reviews, each of which have come to the same conclusion.
Indeed. And the only other material that I can add in terms of understanding of that is that there has been no further HCR 20 assessment other than Miss McCraw's. So the expert evidence provided by the prison-based assessment that I have analysed in the course of this case and these proceedings remains the extant HCR 20 so far as the prison-based provision is concerned. So that may help in squaring it, as it were, that the details of that remain relevant, because one of the matters that I've pleaded in the appellant skeleton is the impact that the decision that we're challenging here has continued to have working through the system in subsequent years, because it essentially says this is the starting point, the court rejected the challenge, that's the position to take. And that has been relied on.
Sorry, just so that I can be clear. Are you saying that there's been no update of the psychological evidence, so that your lay client hasn't been seen again, and
by the prison? I understand there's been further independent reports submitted. My understanding is that the prison have not completed another one. Now, what happens then is that each review has a psychological input, which is a 2-page document or so, that is a contact update, which essentially says there's been no further assessments, etc. There's nothing additional from psychology. That means, therefore, that we're left still with Ms. McCraw's assessment as to whether or not that would properly call for an oral hearing to examine as against the independent expert evidence that you have in front of you, as an issue which still has considerable bearing, as it were, on the extant processes or the more recent processes.
Thank you.
And my lady, we haven't troubled you in the bundle with the pleadings in the 2023 case, but I've referenced them in broad terms in the appellant skeleton that there is a dispute between the parties as to the extent to which the claimant in those proceedings is entitled to raise issues that are said to have been decided in the course of this challenged decision. So certainly one sees the continuation, as it were, of the impact, because the short of it is Mr. Clarke has not been recategorised and has not had an oral hearing in which to advance the issues that he would wish to, that might enable the director to have come to that conclusion or to come to that conclusion in future. So I'm afraid I don't have any further details that I can assist the court with. I've done my best to obtain some information about
Thank you,
the
I'm grateful.
matter. I'm updated. In fact, I may have misunderstood. There has been a further HCR 20 psychiatric assessment in January 2023, which is challenged in a further judicial review.
One that was challenged in the other judicial review is waiting a listing.
Well, that may only serve to complicate rather than assist in any way. There is perhaps further material which is part of the current reviews, but the basis on which the parties are agreed that we proceed before the court, of course, is that if an oral hearing is required, an oral hearing should take place, which will surpass, as it were, the reviews which have been conducted on paper. So in the same way that it was dealt with in the Wilson case, Mr. Justice Ford, which you have in the bundle, and in the same way that matters proceeded before the court in Hassett and in Mackay previously, any judgment that this court makes is not to have no effect, as it were. It will be given effect.
But perhaps not now, because I see communication going backwards and forwards down the line, but perhaps if you could, over the short adjournment, just be up so that we've got a straight edge on what the position is, because of course your part of your submissions, which I understand, is that that the psychological evidence produced on behalf of the respondent in this case is continuing to be used and impacts decisions that are made annually to your lay client's detriment. Now, and I asked the question, well, have there been no updating at all and no reassessment? And your answer was no, but that seems actually not to be, when you're getting instructions, quite right. I think it's important from the point of view of us being clear and potentially in our judgments about what the actual status is, that we have a straight edge on that, please.
I shall delve into that at lunchtime.
Thank you. We don't want an essay, we just need,
Yes, just the facts.
just the facts. Thank you.
Yes, I'm sorry that
No,
I maybe
please don't
misunderstood.
apologise. It's a moving.
So in relation to the facts, the court has those well in mind from
We
the
have.
pre-reading. May I rely, if I were, on broad outline and on the following elements that one can take from the factual material. Of course, there are the basic circumstances in which there's not been an oral hearing at that time for 12 annual reviews. Now we know 15 years, but the absence of a previous oral hearing, the absence of the opportunity to put in the submissions on the local advisory panel, the questions over pathway, whether it would be one or other particular type of route to progress further, the support for downgrading from the independent expert, and the rejection of the LAP's, the local advisory panel's recommendation for downgrade to category B in 2019. Overall, I'll come to what we submit is a list of issues of factual disputes and a list of issues of questions that warranted resolution on the expert views when I come to address you on the grounds. But the background to the matter is that there had been considerable work done, which is set out in the reports in the original evidence, which included the Thinking Skills programme in December 2014, various victim awareness courses, and the Resolve programme in 2016. Now, the Resolve programme is important in this element of the dispute between the experts, that this was a group-based programme, so he had been able to conduct a group-based programme. And moreover, the reports from that are set out within Dr. Pratt's report on our supplementary bundle, page 63. And unless the court wishes to see that now, I can just summarise. It contains a reference to the reports from the conduct of the 25 group sessions in that course, that he was an active and supportive member, willing to discuss his offence and the factors that had led him to commit it, had a good understanding of the material, and was able to apply the skills that he'd learned. Now, those are obviously key things one's looking at for progress successfully from the completion of rehabilitation coursework. He'd completed all the post-programme objectives, and was said to have continued to provide evidence of the use of the skills that he'd acquired. So the background to the dispute, what it all comes to really in the submission is this, that the factual scenario is such that there is a plausible case for downgrade for the prisoner to advance. He has completed substantial work over many years, and it has led to a dossier which doesn't only contain Ms McCraw and Dr Pratt's reports, but contains the evidence of the officers of his conduct in the prison and the relationships and the behaviour that they've seen. And in that regard, there is an officer cook who reports circumstances in which the claimant, the appellant, had been putting into practice some of the learning from the course. There is an officer Reynolds, Lucy Reynolds, not mentioned in the judgment, who records from her almost daily interactions and reviewing his prison record for the year and before, that he is always positive in his attitude and behaviour. He was a role model, exemplary attitude. These are the words that she uses. So this is the strength of feeling about whether his engagement with professionals and staff is positive or is impression management or is simply on a day-to-day basis, such that he is demonstrating his steps towards rehabilitation, what he's achieved so far. She talks also in her report about the evidence of implementation of the thinking skills he'd learnt in the conduct towards other staff and prisoners. He's been asked to help with other prisoners in certain vulnerable situations. He's managed to de-escalate violence between prisoners. These elements are recorded in his records and attested to by these witnesses, and are therefore relevant, one submits, to whether or not there is a suggestion of impression management or a suggestion of actual day-to-day genuine conduct that demonstrates the way in which he has learnt and is applying that insight from previous learning. What is also notable from the probation officer Esther Barton's report, which begins in our supplementary bundle at page 37, tab 4 of that, but I can just give the court these points from it, is that his risk of harm in the community had been assessed as medium and was changed to high only because the guidance had become that you don't change it down from high until they've been in the community for a period of time, 6 months or more, it's suggested. And so she's clear and express it's not due to concerns over his behaviour. So he had been regarded as a medium risk. He's moved to a high risk, not because he hasn't progressed, but because the policy has changed that one remains at that until release or substantial time after release. You then have, of course, the important evidence of Miss McCraw and Dr. Pratt. You can see the points that we've made with cross-referencing in the skeleton argument at page 9, paragraph 9.
Yep.
And so, unless it assists the court to point out where on the page those are, you have the page references.
Certainly for my part, and I'm sure on behalf of the lady and the lord, we've each both read the reports and cross-referenced them to your skeleton argument.
I'm very grateful. So with the skeleton argument was an attempt to put together in that one place a list, as it were, firstly of the positive aspects reported. And again, the reason for that is demonstration that this is not a report which was entirely negative, which says there's no chance, there's nothing to look at, there's nothing to consider, but actually does record the gain of insight, the development of insight into his behaviour and the factors that had influenced him. Does record that his behaviour is consistently applying that learning from the therapeutic programmes, displaying openness in participating in assessments of risk, positive relationships with staff and professionals, that he doesn't have a formal personality disorder, doesn't cluster to a level of disorder. When he is challenging in terms of disagreeing with what an expert might have recorded, he's respectful and is not attempting to discredit report writers, but simply putting forward his disagreement. And there are expressions of remorse, which is a change that occurred in 2015. There'd obviously been a previous element of denial. He'd then begun to accept his role in the offence and to express remorse, which is a step, of course, as looked for in terms of change of attitudes, in terms of the learning of skills. When we look at the PSI test, what has been achieved so far. So we say before one turns away from Ms McCraw's report, it is evident that fairly assessed, it contains a significant amount of recognition of, if I go directly to what the test is for downgrading, development of insight and development of skills that have been put into practice. We then set out in the skeleton at paragraph 10 what we would submit respectfully are question marks. We submit, by definition, these are matters that would benefit from closer analysis. We specifically mean, of course, the benefit of an oral exploration where Ms McCraw's views might be explored and the attitudes, insight, behaviours of the claimant, the appellant, would be able to be explored and an assessment made. Again, we have set that out in a list form with references to the pages where it's found in the report. The court will note that there are a number of areas on which it's clear that Ms McCraw was expressing caveated, cautious, provisional sometimes views that suggested things that could be viewed in one way or needed to perhaps be explored or understood to be relevant to possibilities. In particular, of course, she opens this question up of possibility of impression management, of the potential it could be characterised in that way, where he's asked professionals to meet at a meeting and he's put in complaints about things at times. Now, you have the difference of opinion between the experts about that, but even when Ms McCraw is raising it, she's very clear to be using terminology that it could be considered that way, and it could be viewed as offence paralleling in that way, but also to say that this is not to imply that he is doing that it isn't genuine what he's achieved. And so there's no, as it were, closing of the door on these issues to suggest that they are incontrovertible, settled, final assessments, which will need time and a particular way of addressing before one could possibly look at the insight or the progression that he's made, the skills that he's learned. So we do submit that it's very clear from the use of the language and the expressions that we've referred to in that part of the skeleton, that the questions of what may be needing to be addressed or what may not. And for example, one particular area apart from impression management is that she references that there may be issues with negative associations, because up until the offence period in 2005, there'd been a couple of years of the negative associations, but she raises this as an issue. Is negative associations a particular issue that warrants further exploration? And she references that on page 33, in particular, the supplemental bundle. Now, in doing so, of course, it's apparent from the records that was the time of the offending. There had been cocaine use, there'd been drug use, there'd been relationships with his uncle which were criminal or in that realm. And from that, of course, there could be a concern over negative associates in terms of committing the offences. But what is not looked at is the fact that in his custodial behaviour, he has not engaged in anything like that. He's not hanging around with the bad crowd in the high security estate. He's not causing concerns. He's not receiving negative entries or adjudications that demonstrate that he's doing anything other than buckling down to deal with the rehabilitation with motivation to attend a therapeutic community if he were downgraded. And then one takes the positives and the question marks that come from this report and add her conclusions, where she is clear that while she doesn't ultimately support the downgrade in her recommendation, that's on the basis of matters that could or may benefit from the exploration she talks about. But she is clear, and this is on page 33 of the supplemental bundle, that she does not consider him to pose an imminent risk of violence, and she makes that assessment based on the presence of insight into his behaviour. She accepts this insight into his behaviour, and she accepts evidence of his application of strategies to address and manage any risk of violence, as he's been able to demonstrate. So she expressly accepts two key positives that are relevant to the test for downgrade, and she goes on to say this behaviour would indicate he could be considered for downgrade. Middle of page 33. So ultimately, as I say, while she says, in her opinion, that she thinks there are aspects of thinking and behaviour that could benefit from further exploration, the associates, the impression management question, she's clear about recognising there's certainly been changes since the offending in gains of insight and in attitude and in gains of skill. And there is the question that the court will have well in mind from its reading in relation to whether or not he would benefit from an impression management course, whether he could do that because it was not a group course rather than group interventions. And there is indeed some case law on that topic in the Conroy-Smith case in our bundle, tab 17, where there's an expert talking about the fact that wasn't a course that had recognised benefits or risk reduction effects. But the fundamental question that was before the director here was whether or not impression management was occurring as a fact, and whether or not it was an issue that experts should be able to explore, or should be explored with the experts to determine if it is, and with the benefit of the other evidence surrounding his behaviour, what there is and what it amounts to if there is. Following the disclosure of the dossier, and so far I've talked about dossier content, there's then the representations. The only point the court, of course, needs to note from those, or 2 points, is that there was in bold at the front of those representations the request that there be time for the local advisory panel's recommendation to be addressed in written representations to the decision maker. So that you find in the representations themselves on page 51 in the bold font. Supplemental bundle, page 51 in the bold font. The other element that I would ask the court to note from the representations dated the 10th of August 2020 is the request for an oral hearing, which is on page 54. It's phrased as a request to invite the director to have an oral hearing, as opposed to the LAP to have an oral hearing. That's it on page 54. Accompanying the representations were two reports from Dr. Peter Pratt, who's an experienced independent consultant clinical and forensic psychologist whose qualifications are set out in his reports at page 58, for example, of the bundle, and had read a vast amount of the source material, as is listed on pages 56 to 57, and then on subsequent reports with further material. From that reading, from the assessments conducted in video link conditions, I think at the time, there is an opinion that is in agreement with the 2019 local advisory panel that category B conditions are not warranted, and an assessment that the risk of serious harm if unlawfully at large has indeed reduced to that level. That conclusion, which deals with the the discretionary test that's being applied, is at page 68 in particular. within Dr. Pratt's report, again, the speed, we set that out in the skeleton argument at paragraph 13 as some issues of positive progress that are reported. It does reference the acceptance of culpability, the change that has been in that regard, the progress since entering custody with the consistently pro-social behaviour and good relationships, and relies on that in part to inform his own view on whether there is impression management in the case or not. He notes the protective factors, including family and other matters which are there, which Ms McCall also accepts, and notes there's little or no indication of offence paralleling behaviour. He doesn't accept that the challenging professionals through the processes or issuing a complaint to challenge or an application to seek information is equivalent to offence paralleling behaviour, such as the use of violence, advocating violent solutions. Rather, the reliable pro-social persona is, in Dr. Pratt's view, to the credit of the appellant. And he doesn't accept that there's a need for impression management as impression matters as a cause to deal with, identity matters as a cause to deal with, a suggestion of impression management based on the information Ms McCall has based her contrary view on. And so you have, we submit respectfully, a number of disputes which arise in the expert assessments and opinions, which are relevant to the question of downgrade. They are matters in which there is a value to the oral hearing process, as the authorities would indicate. That takes us perhaps to the decision. You have the chronology in that the 14th of January, the local advisory panel declines to recommend a downgrade. It does so, of course, without the appellant being involved in that process. It's not an oral hearing meeting, it's a meeting of just the individuals of the prison who are listed there, and that doesn't include the psychologists. There is, within that, of course, the reference to Clarke's previous views that there should be a PCLR, an indication that there has been. There hasn't been, because in fact a psychotherapy checklist revised wasn't required. Both of the experts agreed on that. The assessments that there are different assessments. And within that decision making, we have the view reached by Clarke, which the judge sets out in some detail, which we have in our core bundle in full at page 153. Within it, so this is the 19th of January 2021 decision, where we note in the fourth paragraph the resolve programme, and the comment is made: the extent of your treatment gain and full acceptable responsibility for your offence remain unresolved after this work. We submit that's one of the questions which can be explored, attitudes, insight of the individual, most effectively through orally examining that individual, hearing from them. And it deals with the suggestion of no significant risk reduction has therefore been shown. That, we respectfully submit, is not a fair appraisal of the information that was before them, the decision maker, as to the risk reduction that has been evidenced in terms of insight and skills applied and learned. There's then, in the following paragraph, the reference to some allegations, negative information, including possible bullying, which has been, which comes from the LAP, comes from the local advisory panel. It's been nowhere suggested in any of the documents. Post these matters, it is then disavowed. There is then a safer custody report from Mr. Hemingway, but that's all after the event. But at the time, what we have in terms of the process is allegations being raised in the LAP, That is on the 14th of January, sent to the to the appellant on the 18th of January, and on the 19th of January, a decision is taken without any opportunity for that to have been dealt with. There are attempts to deal with it in advance of the March decision, but at that point, there's still no resolution, still nothing come officially to indicate that was an error. But the terminology here on this paragraph is of importance. The learned judge below said that because it's contextualised, because this allegation that's made against him isn't relied on as a finding of fact, or isn't relied on expressly as the reason in which there's no downgrade, that it can be set aside. We respectfully submit, in the context of looking at a shorter explanation of the decision reached, it is relevant that there's been something as serious as allegations that, quite contrary to all of the information about his good conduct for many years, there is a suggestion that in fact there's something with violence and bullying that may have occurred in this review period. And that was clearly going to be something that had the capacity of working consciously or subconsciously on the mind of the decision maker, given that it undervalues or it potentially puts to one side a lot of the other material which has been unequivocally positive. There is a question over level, perhaps, of acceptance of involvement in the present offence with provisos at the bottom of the page 153. That raises the possibility of a question that could be usefully addressed in the oral process. And over the page, similarly, it's suggested from the assessment that there's been of Ms. McCord, there may be behaviour in custody requiring further exploration. That could have been something that the oral process addresses. And the assessment was said to show personality traits are important, and then goes on suggesting impression management and your progress through interventions may be unreliable as an indicator of significant change. That's a question that goes to the downgrading decision to be taken, and clearly an issue that could have been explored, bearing in mind the way in which Ms. McCaw's report is expressed. It's not a firm negative. This is no progress, or no insight, no learning of skills or application. Quite the opposite. So the question of weighing that becomes quite important if one accepts the nuances there which are ignored by this passage. The Category A team suggested that the outstanding matters needed to be further explored and resolved before significant progress could be established. That is, of course, based on the paper approach rather than the oral hearing approach, which could have accepted that there had been the significant change which is referred to by Dr. Pratt, and which Ms. McCaw noted could be a basis for downgrading when she talks about those matters, and accepted that it could be that he's suitable for downgrading on that basis before she gave her ultimate personal recommendation. And then at the final paragraph, the decision makers suggest that the reliance on convincing evidence is to a great extent on the private psychology reports, which present a different view. That may undervalue what Ms. McCaw has said and puts it all on Dr. Pratt, albeit that the ultimate recommendation of Dr. Pratt is positive in terms of downgrade. Certainly, he agrees with a number of the positives that Ms. McCaw herself agrees with. And then it's disputed where it's suggested that the reports recommend, towards the last 4 lines, recommend your downgrading on the basis of your suggested management in Category B, not the correct test for downgrading in Category A. And it didn't believe the reports show that the lap conclusions were irrational. That's obviously not the approach that has to be taken, and there's been some dicta about that, I think, in the Smith case or some of the other authorities. But what it doesn't address is the oral hearing question or the question of fairness to look at these. So there's nothing said in this at all about the oral hearing, despite what was said in the pre-lap representations, there not having been the chance for the further ones. there are, as the court knows, further representations which are submitted post-decision, which are restricted, and I'll come to that when we deal with the policy, but the restricted provisions on which you are entitled to set aside or reopen the previous decision, paragraph 4.36 of the policy. And you can see the decision that's taken on page 155. Two elements to it. The second paragraph is dealing with the whether or not you should be allowed to make representations to us post-mat. And it relies on the criteria in 4.36 to say there's no reason for us to reopen. And it refutes that there's a requirement to allow you to put in the lap representations. Sorry, the post-lap representations. So that's that paragraph. And the final paragraph deals with the oral hearing question. So this is the extent of the respondent's reasoning on that, rejecting that there's a significant dispute warranting an oral hearing, both on the in relation to the representations and in relation to the reports that have been submitted. And at the end it says there's no issues relevant to the review and risk assessment can be resolved only through an oral hearing. And again, we submit that does not address the issues that we've listed and identified that were disputes that could be usefully explored by an oral hearing. And it's not quite the right test to say only by an oral hearing, but the test is whether the fairness requires it to be by an oral hearing because of the benefits that that creates, as opposed to a paper-based decision. I don't propose, in light of the indications, to go any further into the facts at this stage. If I can move on, please. So the legal framework, the court will have well in mind the essential ingredients to this. We set them out in the skeleton by reference to some of the policy provisions in particular, where much of the focus is. The only other point to be made really from the authorities I'll make in relation to the grounds, which is really the value of the decision making in terms of context for procedural fairness obligations, and the correct approach we would submit to balancing of interests and the application of the policy, particularly where it relates to a dispute of fact or a dispute of expert evidence. In relation to the policy question on the representations, could I deal with those grounds 1 and 2? They're set out numerically, in fact, in order of the common law procedural fairness obligation, and secondly in relation to the policy. It might be better just to start with the policy as I put that in the context. I haven't opened the law in any other way. So if I could invite the court to firstly to the learned judge's judgment on our page 46 of the core bundle. I've gone directly to the learned judge's discussion and reasoning. The LAP reps point begins at 85 and goes to 88. I summarise it, if I may, in these conclusions. That at 85, the learned judge confirms his ultimate view that the PSI did not oblige the defendant to allow the prisoner to make representations on the LAP recommendation. And he gives 3 reasons for that in the following paragraphs. The first reason is that the paragraph in question 4.26 is not in italics and is not regarded by the text itself, therefore, as mandatory. So that's reason number 1. You'll see at the bottom of paragraph 86. Reason number 2 is that the language is permissive, so that representations received should be taken into account. But the learned judge says that does not imply, to go towards the middle of 87, does not imply that there must be an opportunity to make representations with respect to the lapse recommendation. So if they're made, the policy would say you take them into account, but you're not obliged to allow them to be made. And at 88, the third reason is that not in all cases will procedural fairness require it. With respect to the third point, we respectfully say, well, that's not necessarily relevant to the policy interpretation and obligation. It may be relevant to the common law fairness question. If the policy does require it, then respectfully, unless there's a good reason to depart from the policy, then the question isn't one of establishing fairness or not, but of adherence to that policy. And there's one further paragraph, 107, which deals with the question of the representations and whether it's unfair. I'll deal with slightly in more detail, I think, when we deal with that as well. So just sticking with the policy interpretation, we respectfully submit that the correct interpretation of the policy is a matter for the court, and authority on that I'll come to in a moment if I may, Mandalia in particular, do have it in the bundle. But perhaps just to give you the submissions on the reasoning of the learned judge that we submit respectfully. We've set these out in brief in the skeleton, paragraph 39 on page 13.
So are you going to ask us to look at the language of the policy at some point?
Yes, I was going to go there with these submissions if I may.
Right.
Because
I was thinking that possibly might be the starting point.
yes, I'm sorry, but so I started with the reasoning just so that we have in mind, as it were, what the learned judge has decided, as it were, that I must challenge and say is respectfully wrong.
Yeah.
Because of the reasons that I'll advance now by reference to the policy.
Okay.
Want us to turn up policy now, do you?
Please. So supplemental bundle, page 108.
Yeah.
So the title page at 108. On the following page, you see the source, as it were, of the reference in the learned judge's first reason. In bold at the bottom of the box on page 109, the note says, all mandatory actions throughout this instruction are in italics and must be strictly adhered to. Ultimately, the difference between the parties, I submit, comes to this, that this appears to say that no departure is permitted. So you have your ordinary public law obligations, published policy, comply with it, apply it, unless there's good reason to depart. But the Secretary of State says you cannot depart from the italics. They must be strictly adhered to. Rather than the respondent's case, which the learned judge accepted, that by not italicising parts of the policy, it becomes entirely public law optional. That you're under no obligation to apply it because it's not italicised. And we submit that in the context of the policy content, it makes much more sense to understand the point in that.
Wall. If you look at page 108,
Yes.
there's a sort of green column just below halfway. Provide a summary of the policy aim, reasons, etc. Provide establishments with instructions and guidelines regarding procedures for reviews of category A / So doesn't that resolve the problem? The policy consists, on its face, of instructions and guidelines.
Yes, my lady, the point we make is a fundamental one, that if you issue guidelines, that is your published approach to be taken to cases of a certain type. You've chosen to do so, of course, you may not be under a public law obligation to make a policy, but you've chosen to issue the guidelines, issue a policy, and it could be practice, guidelines, policy. The same point would apply. This is your published approach for cases of this type. You are free, of course, in public law terms, to depart from it for good reason, but otherwise it is an expectation that you will apply this policy, guideline, practice.
I'm
And
not sure you're engaging with the point I'm making. It's probably my fault. This document explicitly says that it consists of instructions and guidelines. So a guideline isn't something that you're required to do, it's advice.
well, my lady, that's where, respectfully, in my submission, too much is read onto the word guideline in that proposition.
So you're saying guidelines are mandatory unless you've got an excuse to depart from them?
It is a question of application of your policy in public law terms. Your guidelines are your approach.
No.
The entire document is a prison service instruction, PSI 08/2013, but I don't place the weight on the word instruction. It's not the appellant's case that every part of the policy must be adhered to, you cannot depart, but that you apply it unless there's good reason not to, rather than the contrary suggestion, which is that you're under no public law obligation to have the application of the guidelines unless it's italicised. And if one puts that into the context of the guideline of this PSI, we respectfully submit that it's plain that it cannot be, that it's simply a number of optional matters that are not to be applied in the usual run of events, with no duty to follow it. Now, that submission is based on the fact that there's no coherence to what is italicised or not in terms of what must be followed in the usual case. An example would be on page page 114. You have under the reviews of provisional category A section, unitalicised timetable 3.1, unitalicised delegations of whose decision maker are 3.2, and a partly italicised and partly unitalicised 3.4, dealing with what are relevant matters. Likewise, for if one turns through for where there are reviews, the first formal review, 3.31 is not italicised, that there would be a dossier prepared for a review. 3.31, and on the same page 3.35, who it is who conducts the first formal review. And perhaps most tellingly in terms of the this PSI itself, you have at 4.6 and 4.7 on page 119 and 120, the policy considerations for an oral hearing, of which the only italicised parts are on the top of page 120. First and secondly. And the point that the appellant makes by way of interpretation or construction of the policy can be further supported, we submit. If one looks at tab 15 of the same bundle, you have...
Sadly, we have no tabs. Could you give us the page?
I'm sorry, page 125.
Thank you.
So this is 125 of the supplemental bundle. This is a security categorisation policy framework. And it also talks about mandatory actions towards the middle of the page. All groups referenced above must adhere to the requirements section of the policy framework, contains all mandatory actions. And at the bottom, the last paragraph, section 7 to 15 of the policy framework contains guidance to implement the mandatory requirements set out in section 6 of this policy framework. Whilst it will not be mandatory to follow what is set out in the guidance, clear reasons to depart from the guidance should be documented locally. Any questions concerning departure should be sent to the contact details. So that we say is consistent with the public law obligation to apply your policy or your guidance. If you choose to make some of it non-delegable for your own purposes, you can italicise and say it's mandatory. But what you're not saying is we're opting out of our public law obligations to apply our policy, other than that which we choose to italicize. And this policy on page 126 is to be read in conjunction with PSI for category A, because this is the policy for category B, C and D. And you can see the scope of it, its application, read in conjunction, the third bullet point at the top of 126. Now again, if one suggested that only the mandatory section 6 of this policy were mandatory, it would mean that it was not an obligation under the policy to follow without good reason not to. What's on page 129 at 1.2, which is the assignation of the lowest security category appropriate to managing the risk of a prisoner. So the principle
129.
129 1.2.
Thank you.
So this is the principle, it's the lowest security category appropriate. That wouldn't be mandatory, or there'd be no obligation to follow that under the, well, I shouldn't use the word mandatory because it's used, we say, in a specific way in the policy, but it doesn't affect whether or not you're obliged in public law terms to comply with it, absent good reason. And then what is not in section 6, which happens to be on 132 to 133, is, for example, the correct test to categorisation to category D. So the part that's said to be mandatory is on 132 to 133 in terms of policy use. And then the remainder of the policy, which we say public law should comply with, 138. And the decisions to recategorise to category D, the way in which you decide it, what the considerations are, who's eligible, etc. So if I return then to the policy, the PSI specifically, the application of that policy as recognition rather of the public law obligation to follow 4.6 and 4.7, which were largely unitalicised as we saw, is established in which is a Sustain's judgment of Rhodes, which is our tab 12 of the authorities. Could I just invite the court to passages from that? Slightly out of order, it should have been the other side of Hassett. It is a post-Hassett case, but it's tab 12. Sorry, does the court have tabbed authorities?
We do, for which we're grateful.
Paragraph 41 on page 297, beginning bottom of 297.
Sorry, paragraph.
41, page 297. So the challenge was that the director had failed to apply the policy set out in 4.6, 4.7. That was dealt with separately to the other strand of the cases, which is procedural fairness at common law, but dealt with as a matter of adherence to the policy requirements. And at paragraph 42, the ladyship refers to the obligation to follow the policy. We respectfully submit that those are indeed the indisputable principles which are established in the authorities given there. And you have in the bundle also the case of Lumba and you have the case of Mandalia. Mandalia, if I could just draw the court's attention to briefly, it's tab 10. This was the case about bank statements having to cover 28 days, and the provision provided statements had only covered 22 days, so there was a rejection of the application for further leave to remain to study, and there's consideration of the policy that there was about that. And it's what's said in principle about the policy on page 261, page 29, the legal effect of policy. Reference first to the case of Sardi, and then if I invite the court over the page to 262, in the middle of the paragraph, first paragraph, we move on to the Lumba case, WL Congo. And Lord Wilson said that it's the applicant's right to the determination of his application in accordance with policies, now generally taken to flow from a principle no doubt related to adoption of legitimate expectation but freestanding, best articulated by the Justice Laws in Majorada. And the two principles really in that, of course, are it's grounded in fairness to expect that you follow what you've published, and good administration that you follow what you've published unless there's good reason not to. There's citation of paragraphs 35 and 21, some dicta from Lord Dyson in Lumba, which you see in the following two paragraphs. That is the classic statement, of course, of the follow your policy unless good reason not to. And then right at the bottom, perhaps worth noting, Lord Wilson confirms that it's now clear the interpretation of policy is a matter of law. The court must decide for itself. He gives a citation there of the SK Zimbabwe case. And so we respectfully submit that there's nothing in the principles of public law of adherence to a policy or application of your policy that allows the policymaker to have a declaration that some policy isn't going to be followed or isn't subject to that public law duty.
But surely, Mr. Rule, it's a matter for the decision maker what kind of policy / guidance he or she adopts. And if the decision maker wants people to do some things and to pay attention, but not necessarily to do other things, why isn't the decision maker allowed to stipulate that?
Well, my lady, I don't, the submission I make about the adoption of this policy is, yes, you can choose to make some things non-derogable, so that you've said it must be strictly adhered to. There's no good reason to depart. That is not an option. That's fine. You're going beyond your public law duty. You've adopted something which, for your personal wishes, creates a system with some elements that are certain. But you then choose to apply a policy. Now, if the policy says, in a case of X, we may choose Y, Z, or anything else, then the policy you've chosen doesn't have a particular expectation it will be Y or Z or something else. It could be any of them. But if you give a policy which says this is the process we follow, then you are under an obligation for good reasons of good administration and for fairness to follow your policy unless there's a good reason not to. And that's...
Well, I'm not sure I follow that. Because this isn't statutory guidance or anything like that, is it? It's simply issued by the Secretary of State, presumably under broad powers that are conferred on the Secretary of State by Section 1 of the Prison Act. Is that right?
It may be extra statutory. He has some powers in the Criminal Justice Act which he exercises to give directions, which are a different type of document.
Yeah, well, these aren't directions, are
no, for the avoidance of doubt, I don't submit there is a legal obligation for him to formulate a policy in statute. He may have chosen to do so in this case because of the need for certainty where you have things that involve important areas where there may be rights involved. But what we submit is that he's chosen to adopt a policy in these terms. If the policy says, as we look at in a moment with 4.26, this is what will happen, then that is what will happen, unless there's a good reason not to. Assuming it's not one of the italicised one where you may have set your bar even higher. But that's the submission we make about once you've chosen to adopt it, what your obligation is in relation to it. And of course, what its content is has been a matter for the decision maker.
I see. All right. Well, I have your submission. Thank you.
Sorry,
No.
I'm sorry to interrupt. So you've been talking to us about 4.6 and 4.7 in the policy, which deals with oral hearings and is in very general terms approach the decision in a balanced and appropriate way. Consider it on its own facts. Here are some factors which would tend to suggest an oral hearing is appropriate. So it's perhaps to call it policy is putting it a bit high. It genuinely is guidance to the decision maker. But these are matters which tend to point in one direction rather than another. That's what the document's saying.
Yes.
I'm sorry to interrupt. I thought that your point was that the policy, on its proper interpretation, a few paragraphs on, required the prisoner to have sight of the LAP report and the chance to make representations on it before the decision. I thought that was your point on policy.
It is, my lord. It is. And I think the issue is that the court is putting to me, I think, a proposition which is that guidance or guidelines might be of a different level of requirement to adhere to than policy. My submission is that that is not a distinction that arises. It's policy, practice, or guidance. If one goes back to what it can amount to policy, it doesn't have to be called policy. The terminology, I think, is apt to mislead. If one might publish it, call it prison service instruction, as they do. One might publish it and call it policy framework, as the newer versions are now called. But within that policy framework, there are bits which we've established are not mandatory on the Secretary of State's own approach to his delegations or to decision makers that are following the policies. What we don't accept the proposition that there are parts of the published document which don't have the public law obligation to adhere to unless you've got good reason not to. Well, they may be that it's an obligation to have regard to factors that tend in a certain way, unless there's good reason not to.
That's the oral hearing section.
Yes, yes.
The bit about what the Category A team must look at and what it must do. I mean, for instance, in 4.26, the Category A team will consider the prisoner's reports, i.e. what's in the LAP dossier. I mean, if, to take an absurd example, the Category A team was sent the dossier and put it in a drawer and made the decision without even looking at it, that would obviously be challengeable, whether you call it on public law grounds or your unlawfulness. And that would, you would say, well, that's what the policy tells the team to do. Perhaps inevitably, I suppose you wouldn't expect anything else, but that's what the policy sets out.
There may well be overlap. I think, as my lord adverts to, it would be a Wednesday unreasonableness to not having regard to relevant matters. So there may well be that overlap, and we would submit there is that overlap, and there's the overlap in common law fairness, because we say if we failed on the policy, then it's clearly unfair as a matter of common law requirements not to allow the representations to be given that 4.26 talks about. But if I stick for a moment with the policy element of the challenge, what we say is, this is the second point the judge makes about the permissive language. So the second point that the learned judge made in dismissing this ground was that it's in a permissive sense, and that, if we look at page 123 and 4.26, we submit must be the case because, of course, not every prisoner will submit representations post the lap. So there's no obligation on the prisoner to do so, but that doesn't implicitly mean that the prisoner who wishes to do so isn't entitled under the policy to do so. There's no obligation to put in the first set of reps either, but clearly fairness, if I put to one side, but we submit for the policy itself would anticipate that. So 4.26, if I just put it in its context, 4.25, you have in italics the report's representation of the lapse recommendation must then be sent to the category 18 as soon as possible. At this point, the prison will forward the lap report to the prisoner. So the lap report goes, in the context of this process, it goes to the prisoner at this stage, not after the process is completed, but it goes to him at this stage. That we submit implies that there's a reason why he gets it at this stage, which is that he can make representations upon it. Otherwise, there's no point in giving it to him. So clearly there's some purpose to a system that provides the lap recommendation at this same point.
Sorry, so just pausing there, you would accept then that there is no express obligation of the type that you're contending for?
Yet it has to be within the, it will, if you go to 4.26,
Yeah.
the
I'm
last,
looking at
the
4.26.
last sentence, it will also take into account or forward to the DDC any representations received following the prison lap consideration.
Yes.
So it's permissive because there will not always be representations, but if there were representations, we say it's a policy obligation to provide those. And implicit in that, if you've been asked, if you're told there are going to be some representations, you've been asked for that, it's implicitly within the policy that you will forward those. So you'll allow those to come to you.
My
So we have
question
to
is quite
imply-
a straightforward question. I'd just like to know whether or not you accept that the position that you're contending for is not expressly stated in that sentence.
Yes, the time to make the representations is implied, we say.
Right. Thank you.
And we seek to imply that from the fact that there is the express provision that you will take into account those.
The test for implication is whether or not what you're seeking to imply is necessary. Is that right?
If one were construing it as a statute, yes, I would.
Well,
Say
what
one
other
out.
approach are you contending for?
What one has the context and the purposive approach that if there is provision for the lap recommendation to go to the prisoner and provision that his representations upon it would go to the decision maker, in order for that to have bite, to have function, then the implication is necessary. One might use
Sorry,
the word necessary.
I'm so sorry. I just want to be clear what your submission is, please, Mr. Wool. Are you accepting that the test for implication is whether the implication is necessary, having regard to the purpose and context of the document?
Yes,
Right. Thank you.
I'm terribly sorry again to interrupt. So what are we to read in? Because obviously it can't be open-ended, the period for representations to be made. Are we supposed to read in somehow a particular period?
it would have to be reasonable in the circumstances as to what, which is why it would have some relevance that you've been asked specifically.
So would you be able to formulate, please, what text you say is necessarily implied in paragraph 4.26?
In order to comply with 4.26, a reasonable opportunity should be allowed for the prisoner to do so.
Thank you.
And the third of the reasons that we deal with on this ground is the suggestion that because there are representations earlier than the local advisory panel, that is an answer to not being able to provide representations after you have the local advisory panel, and 4.26 in its approach. We submit that is not an answer to whether or not that's a requirement or whether that's fair. When one turns perhaps then to my next ground, which is the common law fairness requirements, as they...
Sorry, before you move on, I'm so sorry to ask another question. May I just ask, please, would you accept that the reasonable period that you said, the reasonable opportunity that you said should be implied in para 4.26 must be a shorter period than 4 weeks because of the effect of 4.25?
Yes.
Thank you.
And my lady, on the question of both whether it's to the policy interpretation or whether it's to the common law requirement, we make 3 practical points about the context of the local advisory panel recommendation and the system that we are discussing here. The first is the weight that the local advisory panel's recommendation can carry. It's clear from the authorities that a negative local advisory panel recommendation could be dispositive against the prisoner.
Well, how do the authorities establish that as a legal proposition?
Well, if I rely to some extent on the 4.7 formulation, there will be issues where there is disagreement between, or the LAP has given a positive rather. So one example of where an oral hearing might be required to consider downgrade is if the local advisory panel and a psychologist have recommended downgrade, but the director's not minded to. That might be a basis for an oral hearing. So certainly in the authorities, disagreements where you have parole boards that have reviewed people who are post-tariff, or you have local advisory panels who have said we recommend downgrade but the director doesn't. That is a platform on which there may be a dispute that needs to be looked at, or an issue that needs to be looked at through the oral hearing process and then resolved thereafter.
So I think my lady's question was, is there some kind of legal principle that enables one to say, oh, well, yes, as a general rule, if a local advisory board says no, then the director will generally go along with it. That's so woolly, it's hardly a legal principle, is it? But
no, it's. I think we're now into the, I'm not giving evidence, the statistical issues over practical experience. If you're getting a negative lap, what's going to happen?
I can well imagine that that's the case, but I mean, it doesn't with respect seem to me that it is any more than that, what one might generally expect. If all the people on the ground are saying, for goodness sake, this chap still presents a significant risk, and it's not been reduced, well then that's bound to carry weight, isn't it?
Yes, but of course they may not have said that. They may just it may be some people say one, some people say another.
I know,
one recommends,
yes.
Or they say, well, last time we said it was enough, but the CART didn't agree with us last time, and I've seen this circularity, where CART didn't agree, so now we just follow the line with CART and say you're still not suitable because CART says you need to do something else. So, but anyway, the point, if it needs statistics, I probably can't assist the court on it today. But what I submit is perhaps can be accepted is the principle that there is weight added, there's weight carried by a local advisory panel's recommendation, and that's probably all I need to ask the court to accept in terms of putting in the context what the point is of a representation made upon the LAP recommendation, what it can go to. The second point is that the local advisory panel can raise matters which are not in the written dossier, as happened in the Claimant's, the Appellant's case. But certainly, because of its nature, it comes at the end of the dossier, at the end of the process, and with oral attendances, it can bring up new material that you've not yet had any chance to deal with. An example in this case is the bullying violence suggestion that had not been anywhere else and which was wrong, which the director didn't know was wrong when he made his decision. And the third practical point about the lap is that it's not a oral attendance at which the individual is present. So it isn't the type of situation. Some categorisation reviews invite the prisoner to be there. This is done in his absence, so he's not able to participate or to add information prior to any chance to make written representations, because he's not present at that hearing, or at that panel, sorry. So I've mentioned already that obviously he wasn't able to highlight the issue about bullying and violence that had been raised, nor was he able to deal with PCLR not being required, rather than assumed to have been taking place, which is what the local advisory panels say. The learned judge did accept paragraph 107, which I said I'd mention again. This failure to have the opportunity for the representations had the potential for being procedurally unfair. But in essence, and this is his paragraph 107 on page 49, in essence, the judge said that despite being potentially unfair, the appellant was able to make representations after the final decision, and the court hadn't expressly rested its decision on a finding of offence paralleling bullying or violence. As to whether in principle that's correct, that the opportunity to invoke 4.36, which is in restrictive terms, I haven't taken the court to it, but you'll have seen that on page 124 of the supplemental bundle, that it's an opportunity to write in, and the director may retake the decision where he or she considers the representations highlight information not previously considered that could materially affect the decision. That was rejected in the March decision. That's the stricture of the terms. So it's not a sort of free review or further fresh review. It is a reopening or a setting aside type of request. So it's something brand new. Leaving that aside, on the principle of a post-event representation, post-final concluded decision, we would respectfully draw attention to the principles that have been applied in other cases where there's an important decision to be taken that has bearing on an individual, which invoke the requirements of procedural fairness at a time when matters are still provisional and they haven't yet crystallised into a final decision. One example of that is the provisional minded to indications that are given in age assessment cases, and we've cited the case of FZ as a Court of Appeal authority on that, and I know there have been more recent Court of Appeal authorities that some members of this court have been involved in. But that's one scenario where the common law recognises that it's only fair to have an opportunity to deal with those allegations or those matters of concern before the final decision is taken. It's not enough to review it afterwards. The other example is the authority of Balajagari in the bundle. I'm going to invite the court just to look at a couple of paragraphs in that, because the principle we submit is of importance. And there's some overlap in that case is concerned with a decision making by Secretary of State where there's a suggestion has arisen of possible dishonesty or reprehensible conduct. So this is our tab 15. So this is the decision making where an individual is applying for leave to enter or remain, trying to satisfy a certain income threshold that they previously declared a different income to the Inland Revenue. Well, that's the suggestion, that there's been a difference in the income declarations. And so there'd be an opportunity to refuse on the basis of reprehensible conduct or dishonesty. But the Court of Appeal in Balajagari found that there was a requirement to, as a matter of procedural fairness, to indicate the matters and give the applicant an opportunity to respond and do so before reaching a final conclusion. And there was a reason why an opportunity for administrative review later wasn't sufficient, or the principles why I set out. So if I just invite the court through, please, to page 403, we'll see that the discussion begins there in relation to procedural fairness. at paragraph 46 on page 404, the court references procedural fairness as an objective question for the court, not whether the decision maker has acted reasonably, still less whether there was some fault on the part of the authority. And reference then to Osborne in the next paragraph. And this is on the principles that underpin procedural fairness, of course, and its purpose. And in relation to not accepting a post-event administrative review following an initial refusal, that's paragraph 58. Court rejects that as being an answer to procedural unfairness. And at paragraph 60 gives the principal reasons why it's insufficient to have that opportunity after the event. Paragraph 60 on page 407.
So is there a paragraph, please, that just tells us what the facts of these cases were, so that we've got a context for the observations about procedural fairness?
Well, perhaps if I can come back to you after lunch. I just worked from the head note and my previous readings of the case in relation to
Yeah, so I
facts and
haven't looked at this for a while, and I just can't remember what the facts are. So it'll just be helpful to know which paragraphs will help to explain that, please.
I'm reliably informed paragraph 7 might be assistance.
Right. Look at that.
So you'll see the facts of each case there.
Oh, that's very helpful, thank you.
So, my ladies, my lord, we submit reasons why at paragraph 60 a post-event review doesn't satisfy the original requirements of procedural fairness, where you have something like an allegation made in which there needs to be an opportunity, while a matter is provisional, to address it, would apply equally to the circumstances of the appellant's case. And of course, the court has the point that a specific request had been made to be able to deal with it in this case. So procedural fairness on the individual circumstances, quite aside from the policy, there had been that request. Then, if I may take the remainder of my time on the oral hearing question, these grounds are subdivided, as the court will see in the skeleton, beginning at page 15, paragraph 41. The first ground 3, concerns the importance of the category A decision-making process and consequently the high standard of procedural fairness required.
Sorry, paragraph which in the scope argument?
Paragraph 42, please.
Thank you. Sorry. Thank you.
So, in essence, what we respectfully submit is that the learned judge, in setting out elements of this court's guidance in Bassett and Price, sets out that which is not itself incorrect in any way, but which, of course, is one side of the equation that Bassett looks at more carefully, and we submit the authorities have looked at more carefully generally, which is that whilst category A decisions are administrative decisions not to be equated with the parole board, there remain important consequences, firstly, to the decisions that give them context, and secondly, values to an oral hearing and its process, which are common to common law fairness and have application, as Hassett says, to this type of category A review as well. And so those passages are important not to overlook, and they are not passages with which the learned judge's judgment dwells. They are recognition of the importance that the parole board, the category A review, despite not being a parole board decision, remains, and that includes the importance it has for the individual in their progression and their ultimate liberty. And the court was expressed in adopting and upholding what had been said in a previous Court of Appeal case of Mackay on this very subject. And so you have in Hassett no difference between that and what is said in Mackay as to the importance of the matter to be weighed in the specific context.
So can I just interrupt for a second, please, Mr. Wolf? Do you say that anywhere in the judgment the judge expressly erred? You point to a sentence or a paragraph in which the judge downgraded the importance of the decision.
Yes, well, the judge sets out parts of Hassett which, as I alluded to, don't include, we respectfully submit, the values of an oral process, what it achieves, why it's required.
Perhaps you could take, would it be helpful if we went to Hassett and you took us to the paragraphs which you say the judge, to have presented a complete and fair picture, should have included in his judgment?
Well, the judge was clearly referred to Hassett. You argued the case below, and presumably you referred him to all the passages that make the points that you're about to make now.
Yes,
Yes,
I don't suggest I didn't.
No.
The question is whether he.
So is your submission that because the judge didn't set out all those passages in the judgment, he somehow misunderstood Hassett? And I'd just like to understand what the submission is.
No, what my submission comes to is this: that if you look at what he does take from Hassett, it is the very much decided on the administrative decision making and on those aspects of it. It deals with those in paragraphs 58 through to 65 of the judge's judgment, pages 41 and 42, and doesn't refer to the other elements that Hassett does contain, which are the importance nonetheless of fairness in this context, requiring hearings, if compared to the parole board, comparatively rare.
So it boils down to a criticism that the judge inadequately summarised Hassett. Is that it?
No, it's the fundamental point. Did the judge, in making his judgment, correctly apply the principles of common law fairness as to when an oral hearing is required?
Right.
What I don't accept is the suggestion that Respondent makes in the skeleton, that I contend for a new, different test than is set out in Hassett or Mackay. No, the test to be correctly applied can be understood by understanding Hassett and alongside Mackay, which it endorses, and the authorities that have applied the policy since, so that they give you an instruction as to the way in which the dispute of expert materials or the dispute of facts may require an oral hearing. What this judgment does is not apply those elements that properly applied do require an oral hearing in the circumstances that present themselves. So it's not a brand new test. What it is saying that the approach the judge takes, which is about a focus on prediction of an outcome and asking whether there's reasonable reasons for refusing or reasonable reasons for a view taken or justification, is not the correct approach. It's not the correct approach that Hassett provides or that the other authorities that it endorses provide.
Can you show us and express misdirection by the judge?
So in the part of the judgment dealing with oral hearings on page 46,
Yeah.
at 89, the judge is, at the end of that paragraph, refers to the reasoning provided on the 25th of March and suggests the reasoning is consistent with the published policy. That is an indication that there is a review of the reasoning. Now, I don't on its own say that that is a fundamental error. One's got to have regard to the reasoning, of course, that is given, but one also has to be conscious that your decision is, on the facts, is there a requirement for an oral hearing to do fairness?
Well, hold on a
under the
minute.
policy
Isn't the
and-
judge there dealing with the submission that the defendant failed to apply the policy in deciding whether or not?
Yes, he deals
Can you
with
look at the first
these two
sentence?
grounds. The oral policy point and then the common law fairness point follows, yes.
So what's wrong with the reasoning in paragraph 89?
If one goes on, that it's nowhere does the judge adopt.
But just hold on a second, please. Is there something wrong with the reasoning in paragraph 89 or not?
Not on its own. I
Right.
need to make the point that my lady wants, which is from the omissions which I can't take you to.
Yeah.
How do I indicate from anything that is there that those omissions may be important or maybe in the context of where he's
Find the judgment
it's quite-
overall.
So what are the mandatory relevant considerations that the judge left out then, please?
on the that then requires me to go to the policy
Right.
and
So we're back to 4.7, are we?
well that and also as I'm dealing with the common law, also the Mackay judgment and others, I'm trying to answer the question, but I'm being perhaps
Well, sorry, maybe I should just
Told in-
stop asking you questions and just let you develop your
no,
suggestions.
it's much more useful if I'm answering my lady's questions, but it's just not an easy answer in that it almost requires you to
Sorry.
take a cumulative look at what I am about to set out rather than what I
Okay.
can set out in answer to a question
All
as
right.
to what was the judge.
Well, I'll keep quiet. I'll
So we
keep
press
quiet now.
pause on that, but
Yes.
keep it in mind
Yes.
so that when you've developed your overall submissions, we can see how that fits with what her ladyship wishes to know.
I'm very grateful, and my lady, please obviously do say if I haven't answered it when.
We'll keep asking,
is-
don't worry.
I'm grateful. It is.
But you must be allowed to develop your submissions, so please take your own course now.
I'm very grateful. The point about principles of importance is that, of course, there was in Hassett the recognition of the principles from Osborne on the purpose of procedural fairness and on the not making matters dependent, an oral hearing dependent upon perceived prospects of success in downgrade at the oral hearing. And those matters equally apply, although, of course, everything is looked at Osborne principles through the context of Hassett and the context of it being category A. But those purposive principles as to what the value of an oral hearing is, when it would be required to do fairness, include matters which don't find a resonance in the judgment below respectfully. They are the importance of the matter to the individual, the lack of predisposition to official reports, not dependent upon the perceived
Sorry, I'm
outcome.
trying to
Sorry.
take a note. So importance to the individual.
The absence of predisposition to official reports.
What does that mean?
It's Lord Reed's paragraph 90 and paragraph 2, Roman numeral 7. But essentially, if you've got a difference of opinion between a prison psychologist and another psychologist, you don't just assume the prison psychologist is right or go with the official reports over a prisoner
see.
challenging it. So just a sort of check on yourself in decision making that you're being fair about what weight you're giving to different things and whether there's an issue that should be looked at. And the third point I made was the perception of outcomes, not indicating whether or not you have an oral hearing. So fairness isn't dependent upon perceived outcomes if you receive it. And that goes back to what his lordship said about the value, what you learn from better decision making from the oral process.
So you say that the judge didn't expressly refer to those factors, is that the submission?
Yes.
Right, thank you.
The Mackay case, can I just be forgiven for taking the court to 2 paragraphs from that?
Of course.
It's tab 5, please.
Just a moment. Your lay client wishes to say something.
Is it possible I can just go to the toilet, please?
I'm sure I'm sure Miss Clarke won't mind if we carry on in his absence.
Of course not, no. Thank you.
Then certainly, Mr. Clarke.
Thank you. I didn't have express instructions on that, so I thought I'd just ask.
Well, I prefer just for us to keep going. I think we're talking quite technical stuff at the moment.
Indeed,
I don't think the
indeed.
lay clients get.
It's rare perhaps to have the audience sometimes. But,
Indeed.
so Mackay is this court's judgment, which is considered in Hassett, and in particular, what has been endorsed and considered in various cases since. The matter stated at paragraphs 25 and 28. On page 50 of our Bible, you have paragraph 25. So this is on the point of the importance of the question at hand, the importance of category A categorisation, which informs the requirements of fairness. And if one goes to 28, please, on bottom of 51, the first point made is that it's for the court to decide whether an oral hearing is required or not a question of reasonableness or rationality. Over the page, there's reference to oral hearings being few and far between. Advantages may be improved decision making, bringing Clarke into contact with those who have direct dealings with the offender and the offender himself. An oral hearing may also assist in the resolution of disputed issues. So the importance of it and the value of an oral hearing in this context are not inconsistent in any way with what is said in Osborne, nor what is said in Hassett, which expressly refers to this part of Lord Justice Groce's judgment. It's this approach has been referred to also, both Osborne and Mackay, in other first instance decisions since. But I focus on the points of principle that they endorse and which need to be borne in mind when considering what fairness requires in a category A case. We've set out in the skeleton.
Your lay client's returned.
I'm sorry.
Your lay client has returned.
Thank you very much. We set out in the skeleton some other points in relation to the impact of category A and cases that have considered it from paragraph 44 onwards. But essentially, the important points have been made through reference to that dicta.
I don't think there's anyone in this court would underestimate for a moment the importance of this decision to your lay client for all the reasons identified in Mackay and amongst others. I don't really think it's necessary for you to expand any further on that.
Well, lady, that and again, it's, I think, not in dispute with my learned friend either, as my lady points out. So the question
on the ground, is, as between yourselves and complies with the understanding of this court.
So the question is whether the learned judge in his decision has had adequate regard to that importance in the principles that have been brought to bear on the outcome. The fourth ground deals with the judge below taking an approach where the perceived likely outcome or defending the outcome on the current material has been borne in mind in deciding whether or not an oral hearing was required. And we respectfully submit those are not the right questions to ask. The question is simply on the facts, whether, bearing in mind the guidance and the policy and the common law principles, there was a need for an oral hearing to do fairness on the facts. The perception of likely outcome, or whether you can defend as reasonable the outcome you've reached, are the wrong questions to ask. And the learned judge does so, for example, at paragraph 109. Where at the end on page 50, it concludes that it was open to the Clarke to reach their own view which set of opinions to prefer simply from reading the reports. An oral hearing would not necessarily have illuminated the issues more clearly, nor would it have been likely that either of the experts would have changed their position as a result of an oral hearing. Those statements, we respectfully submit, don't reflect correctly the principles that needed to be applied or the policy that needed to be applied, which do not focus on those outcomes or perceptions of outcome or justifications for an outcome, but rather on the potential that an oral hearing adds value. Obviously, if the disputed issues exist but there is no value to an oral hearing, applying the proper principles, whether taken from the common law or from the policy, principles that there is something to be gained through that examination which satisfies the requirements for when an oral hearing is needed. And the examples that exist for that, we respectfully submit, are evident in the case that the appellant represents, because the issues that were relevant to be decided are set out, as the learned judge records in the judgment, those which we prayed in aid. If I could just invite the court's attention to what those issues are. Paragraph 71 on page 43. These are 4 factual disputes which could be, and we respectfully submit, on the authorities and the policy should be addressed through the oral hearing process. So factual disputes set out there, A to G, and real and live disputes between the experts at paragraph 72.
Sorry, just pausing the list of facts in paragraph 71.
Yeah.
It might be said against you that those are all actually matters of opinion rather than questions of fact.
Well, my lady, the question, obviously experts can offer opinions. If they do so, they base that on either assessments or on information they've read.
Yeah.
But there is a question of fact that could be established through the examination of that evidence. Is he managing impression or is he not? That could be a factual finding by a decision maker that I've heard an opinion that it might be oppression management to have raised this complaint. But when I heard what the complaint was and the circumstances, I thought that was a legitimate thing to do. So I don't find that's impression management or offence paralleling or that type of thing. So there is definitely overlap, I accept. But in trying to put this in terms of the policy, one tries to put it in terms of what could be a fact that's in dispute and what could be an expert issue, an opinion that's in dispute.
Could you help me with one matter from a position of ignorance on my part? When these oral hearings do take place, I mean, I don't know how often they are. I mean, they're very rare, I'm told, but, you know, that could be, you know, 1 every 10 years, or it could be, you know, 1 a month. I don't know. But what format do they take? I mean, are we talking about just looking at our case for the moment, this appeal? So you'd have both experts and then what, various prison officers, people that conducted the assessment, people that ran the course. So what are you talking about? 2-3 week hearing?
No, a parole hearing will usually hear from similar panoply of individuals.
Right.
So officers who provide reports, officers who've read the records, experts, etc. Typically, that's going to be less than a day of hearing, but one should also.
They'll hear oral
hearing,
evidence from all of those people in less than a day.
Yes.
Okay. That's because everyone's read the reports and it's testing on very specific points.
But
we could get a bit more of that around the place.
Well, it's certainly perhaps a more inquisitorial rather than adversarial process.
All right.
I should make this point is that I'm not saying that is what would happen in the appellant's case, because there's a flexibility which is probably the greatest in category A oral hearings than anything else.
Understood. So what would you be
focused on?
Yeah. So, I mean, I'm not asking. Well, I am asking you to give evidence, but what in your experience would be the sort of length that one would expect an oral hearing to take?
I'll need to come back to my lady on that if it's appropriate to do so.
Well, don't. I mean, I'm not asking for it. That this is to increase my knowledge.
No. I know.
My next question.
I know a solicitor who deals with them a lot. I could speak to her, but it's going to be giving evidence in a way.
No, and
but in practice, Mr. Wool, what you're suggesting here, well, I might have misunderstood your submission, is that both of the experts would have had to give evidence and be cross-examined?
Yes, this is usually the examination on behalf of the prisoner as well.
And probably in the light of the submissions you've made right at the beginning, various other people that have observed his behaviour in prison. The person, was it Reynolds? Someone that's called Reynolds that sees him daily or something?
Miss Reynolds, Lucy Reynolds.
Those are the type of witnesses.
So they would not always be necessary.
No.
I only would accept that they may be appropriate because of the issues about facts, about was there, describe your relationship and why is that good or bad, and there could be 5 or 10 minutes where they've got something to answer.
I understand.
So I wouldn't exclude it, but I wouldn't say that would be the usual course. But there is this flexibility. So the reason I think you don't have particular evidence about how these are conducted is that there's not one way of conducting them.
But would I be safe to draw the conclusion that they tend to be relatively short, highly focused hearings, which will nevertheless involve expert evidence and cross-examination? Does that sound like a fair?
I don't know if I may be in a position to take more instructions as well. I can certainly confirm that over lunch.
It's just I want a feel, given that the heart of your case, or one of the main planks of your appeal is there should have been an oral hearing. I just feel for my part only, I need to have a better feel, and which I now do. Thank you.
My lady, I think those points would flow from the way in which an oral hearing we submit becomes necessary, because it needs to explore those particular issues. So those would be the relevant people.
Which is why I highlighted those as your potential oral hearing.
And what's the tribunal?
It's the director or the...
sitting on his or her own?
I'll need to double check.
No one's ever done one.
No.
I'll have to ask someone I know who has.
In comparison to a parole board hearing, for somebody like this, one of the non-judicial members would probably be a psychiatrist, wouldn't they?
Certainly psychologists.
Or psychologist, certainly somebody with that kind of expertise. Whereas this, I mean, I assume it would be the deputy director or his or her delegated person.
It is the director. I know Steve Easton used to be the individual who did them. The reason I don't immediately have an answer as to whether he's on his own or not, I know he doesn't, but whether he's on his own or not, is that I know that there are other reviews where he does involve other individuals, including a psychologist and others, police and others.
All right, Mr. Will, actually, on that point, I think it would be helpful if you could make some inquiries over the short adjournment. I think that's a purely factual matter that I presume, Mr. Urban, you've no objection to us asking for that extra piece of information.
Not really.
Thank you.
And who would do the cross-examining? Would it be the director, or would the director have to bring in somebody else so as not to compromise his objectivity?
I don't know the answer to that. I know that the representative for the prisoner asks questions.
Of course.
This would be the person that I shall ask for an
No,
answer.
that wasn't the point of my question.
Yes, as to what the director does, whether he asks questions himself or whether someone from the prison does on his behalf, I can't answer that at the moment.
Thank you. I'm sorry, we've taken you drastically. Oh, I have taken you drastically out of course, but it's been very helpful to me. Thank you. All right. So we've got your paragraph 71. We've looked at the issues which is what led us down this rabbit hole. That you feel an oral hearing could legitimately and appropriate address, and indeed should have been given the opportunity to address.
Yes, and
Lying,
sorry, mate.
no, just that's your case.
Indeed. So yes, this is a summary of the factual points that we rely on in 71 and 72, where on an analysis of the reports of Miss McCraw and of Dr. Pratt's evidence, one plainly has issues which we would submit are able to be dealt with effectively and fairly through an oral hearing. And the reason that is so is the nature of the process that's been described in the authorities that we were just momentarily looking at. So the judge, on the other hand, where I've just taken you to one particular paragraph, but several paragraphs in advance of that deal with the reasons that have been given or the open to Clarke to conclude an oral hearing, doesn't. So that's paragraph 100 as well, or a reasonable basis for Clarke to conclude at 97. These are the examples where we say if one reads that, if the judge had gone on to say the reasons are reasonable, I've taken into account, but I find that the disputes would not benefit from an exploration. They don't meet the requirements of for an oral hearing in fairness, because then made his own decision clearly rather than a review of reasonableness, then one would be more perhaps assured that there had been the appropriate test applied where the court decides on the facts whether an oral hearing would have achieved fairness and was required. And so when this is, I think, where I'm accused of a new novel test that is radical and just goes any benefit to a hearing. The point that I've sought to deal with is that when you're analysing the benefits of an oral hearing, or the need for an oral hearing rather, clearly there has to be some capability of it to have some benefit in terms of resolving the issues and in terms of placing the prisoner in an improved position to obtain recategorisation at that occasion or later. But that's not to be said that you have to demonstrate an outcome before you demonstrate the need for the oral hearing.
So are you saying that the extent to which the issues might be resolved by an oral hearing is relevant?
Yes.
Isn't that what the judge was looking at?
He's accepted the reasoning that that you could justify findings made on paper, but without, we respectfully submit, being correct as to whether the facts of this case had matters that required to be looked at through the oral hearing in order for fairness to be done. There is the difference of approach we submit is this: one can decide these are decisions taken. I review them; they appear to be reasonable basis for making those decisions, and I say judicial review ended. Or I say, well, actually, I take into account what's been said, but I have to apply principles that are set out in the case law of Lord Reed and Lord Sales and Lord Justice Groves, and I have to bear in mind the policy matters in 4.6 and 4.7, and decide whether an oral hearing was required and or required by the policy. Between that and saying that you could justify the decision taken on a reasonableness rationality basis by looking at the reasons that are given, and I'm not going to say they were it was a Wednesbury unreasonable decision. And whilst he doesn't use Wednesbury as a term, the references to reviewing to the reasonable bases or the basis or open to Clarke to decide, etc., is not indicative of a court making its own view, applying those principles that it needed to.
But isn't the judge just in paragraph 109 asking himself whether or not an oral hearing is required by procedural the need for procedural fairness, and he's giving a series of reasons why he doesn't think it was.
Well, lady, my submission is that you have an indication from the way in which the phrasing of the judgment is that there was a review rather than a decision by the court itself as to an assessment of all the facts, what was required. And the alternative position is that in any event, the judge is wrong, respectfully, on the facts of this case, to say it was not a case that after 13 years in custody, having gained the insight that Miss McCraw noted, having gained the position that is noted to be one where he could be downgraded, that there was simply nothing to be gained by looking at that in any closeness to enable a decision to be taken, with the support of Dr. Pratt for downgrading being met, and the issues, question marks that are raised by Miss McCraw, which would be amenable to benefit from the oral hearing. And that's why I talk about the benefit of the oral hearing, but that they are amenable to it. They're the types of things that could be usefully explored, resolved, and potentially have impact.
Thank you.
And that is one reason that we rely on my Lord Justice William Davis's decision in Morgan, in that we analysed the decision there as having clear regard to whether or not there were real disputes about matters of fact, and whether an oral hearing could take the matter any further, whether it had any benefit to it, whether it could be of use. And that's something which appears in the analysis we submit at paragraphs 46 and 47 of Morgan. So the useful exploration at oral hearing question is obviously of relevance, and that is an appropriate question on the common law test to be asking. We've analysed the learned judge's conclusions about the factual disputes and the bullying allegations and other matters in the skeleton, paragraph 49. And we've respectfully pointed out where we say that there are disputes there as to whether matters are offence paralleling behaviour, whether there's impression management, the extent of the reduction in risk achieved and the evidence to date, all matters that would benefit from an oral hearing, contrary to suggestion that there wasn't a difference of experts sufficient for an oral hearing in the judgment. The oral hearing process, of course, would, if I just refer to paragraphs 50 and 51 of the skeleton, we have identified that there is the process that brings to light new matters. So part of an oral process, of course, is to obtain new material, information or evidence that comes from the questioning.
Yep.
The second point is the value of the appellant's own oral evidence and the respondent's assessment of it, because it's one of those areas where the attitudes of the individual, where seeing the individual, as was said by Lord Justice Gross in Mackay, those are relevant matters that enable the better decision-making, more aided decision-making and accurate decision-making. And the value of exploration, thirdly and fourthly, of either Dr. Pratt's or Miss McCraw's opinions and their scoring to allow exploration of those matters. And we submit it striking how much equivocality there is in Miss McCraw's report, as identified earlier in my submissions.
Well, is it surprising? I mean, it may just be that it's a balanced report.
No, my lady, it's not a criticism of her report. It's a fact that I rely on, that there will be cases where an expert report on paper can come to a concluded final view that there is no insight, or insufficient insight, insufficient progress, insufficient learning, and therefore not suitable for downgrading. And that might be one form of report, but that's not this report. That's not what this appellant had earned through all the work that he'd done. He had earned the material from Mr. Cook, Miss Reynolds, through to Miss McCraw of the assessments and the indications of the progress that he'd made since the 2016 Resolve course and programme, which he'd done so well with, and then put into practice. So the assessments of that ought to fairly take into account. Miss McCraw does record those benefits. They are directly relevant to the test for downgrading, which is whether there is convincing evidence of a reduction in risk sufficient, a significant reduction in risk, such as the gaining of insight or the development of skills to manage, both of which are evidenced in her report. And so because of that, and because there's some question marks over, for example, involvement with antisocial peers, which hasn't resurfaced in the time in custody, those are matters which don't rule him out of the benefit of exploration in an oral process to identify the extent of the progress or the validity of any concerns or what the next step would be. And ultimately, if the learned judge had applied the correct principles to common law fairness and or policy that require there to be an oral hearing in this case, he would on the facts have reached a conclusion consistent with that reached in Zaman and with Seton, which are two cases that we've set out. And those are cases in which
they do turn on their facts.
Absolutely, accept that, my lady. Absolutely, all of them do. The point that I rely upon from Zaman in particular is the way in which the judge applies the principles which refer to the value of an oral hearing, refer to the missing part of the picture in this judgment, which is if you take into account those principles, then you identify what it is about the expert dispute or what it is about the disputes of fact that need to be explored or that should be explored in an oral hearing. And on our authorities bundle, page 551, tab 20, paragraph 49 is raises the question of important disputed facts and whether an oral hearing is required as a result of those types of things, evidence of offence paralleling behaviours or insights achieved, etc. Commitment to pipe. These are things which are redolent of what Miss McCraw speaks about. You then have the application of principle at 53 and 54, which demonstrate the importance of the utility being considered and the importance of the decision. The types of advantage which we say apply to the appellant's case are the types of advantage identified as a matter of principle that you see applied at 56, 55 and above. And if one applies the policy correctly to the facts, whether the learned judge was indeed, as we respectfully submit in ground 79, wrong on the facts to have reached the conclusion it did dismissal of the application on the oral hearing point, the facts are set out on page 120 in paragraphs 4.6 and 4.7. The requirement that there be an open mind alive to the potential real advantage of the hearing, both aiding the decision making and recognition of the importance of the issues to the prisoner, not making the grant dependent on the prospects of success, flexibility approach as to the oral hearing and what's included, and factors that tending in favour, the important facts in dispute, likely to be important if they go direct to the issue of risk. We say that applies to the facts that I've already outlined in that list that the court has. Necessary to consider whether the dispute would more appropriately be resolved at a hearing. That's the terminology used. Common law uses whether it would fairly be resolved, or but more appropriately in the policy. For example, an explanation or a mitigation where the prisoner's version of events or credibility might be an issue. So the types of issues were around the factual issues of impression management, others, insight gain level, application of those skills, those points. The second point, significant dispute on the expert materials, a real and live dispute on particular points of real importance to the decision. If so, a hearing might well be of assistance to deal with them. Again, noting that where these points could be advantageously looked at. Where a psychological assessment produced by the Ministry of Justice is disputed on tenable grounds. Well, we would submit there's tenable grounds for disputing Ms McCaw's outcome, recommending B, but there's a lot of positive already to take from that. And then there's the disputes on the various points that I've raised that arose. It's emphasised that hearings are not all or nothing, can be targeted on the points that are of interest to fairly decide it. Then you have the lengths of time with someone in category A not receiving an oral hearing. We know it's 15 years, at the time it was 12 years. And the question of impasse with the possibility of pathway, whether impression management identity matters. Once he was assessed, he was ruled out of identity matters, but that postdates the consideration. But it was an issue that had been raised in the representations before March that there had to be, this had to be looked into and said not to be appropriate. And whether he's never had an oral hearing before, again, that is applicable. So we respectfully say at least 3 of those 4 apply, and arguably the impasse point arose on the way in which it was presented.
Can I just ask you a question about that, please, Mr. Wall? Does the word impasse have a technical meaning in this context? Because I've got the impression from some of the cases that it refers to a situation in which a prisoner won't admit his guilt.
I think its origin may well be in those cases because it's not. I would submit it's not a term of art in the policy. You will find it used in the authorities that predate the policy. It's probably used in slightly different scenarios. The typical one might be if you need to be in a different category to do a course that you're said to need, then you're in a totally circular thing. But it's also been applied in cases in cases where you don't know which route is required and there's no opportunity to identify which route without an oral hearing. But that may be also common law cases to do with the parole board as well. So we may be again seeing the crossover rather than this. I can have a look over lunch break in case there's anything.
Yes, I think it would
I
be
can
quite
find
helpful for me to know whether it has the technical meaning that I'd gathered from the few cases I have read, or whether it has some wider meaning.
In terms of the policy itself would suggest that it might have some wider meaning.
Exactly, I think so.
Where there's an impasse which has existed for some time for whatever reason.
And also, if someone's sorry, but if someone's refusing to accept their guilt, having an oral hearing, seeking to understand the reasons for and potential solutions, I mean, that's not going to make a blind bit of difference if someone spent 10 or 15 years saying
No.
that they didn't commit an offence. So I'm completely agree with Justice William Davis that it looks like it's a much wider thing than the.
There were also a line of cases that dealt with the rehabilitation courses that you required, some of which required you to admit guilt to do them. More recent years, there are different courses for those who are in denial, but there was a time at which there was nothing to do if you were in denial and you would reach an impasse because you were said to need to do some work, but no work was available to you.
Yeah,
that was certainly
that's
original.
That's undoubtedly a well-known phenomenon. But the policy would appear to indicate that there will be other circumstances, and if we all sat here for long enough, we'd probably make some up, but I'm not sure it'd be a very, very useful exercise.
I'll see if I can see how the policy's been used in that terminology in case it helps over lunch, but I think it has been in different ways. So unless I can assist any further on points, I'll obviously recognise them.
Can I just ask a couple of questions, please? Just a factual question, if I may, please. When does Mr Clarke's tariff expire?
2032, I think. Yes.
2020,
2032.
2032. I'm terrible with numbers. And just so as I can be clear, I think I've understood your submission to be that the only correct decision on these facts was that an oral hearing was required. Is that right? Thank you.
No. Thank you very much indeed, Mr. Orme. Yes, Mr. Irvin.
Good afternoon, my lord, my ladies. I will address the court in the same order that the learned friend has. So briefly, first of all, touch on some factual matters that he raised at the beginning of his submissions, and then moved on to the grounds as they have been addressed by him. The background facts that he relied upon at the beginning of his submission started off with the submission that there were a number of positive factors that had been identified in the appellant's case and conduct, and that of course is accepted, and the court would have seen that in the various documents that made up the dossier and in the challenge decisions in this case. That's certainly not in issue. And the learned friend also identified that the issue and dispute in this review focused on the question of impression management, and that was the key point that he relies upon. Again, the court will have seen that that is something which is fairly raised as an issue between the psychologists, and it's a matter upon which the appellant had the opportunity to make submissions in advance of the LAP recommendation and did in fact do so. I don't think the court needs to go to it at this stage, but for your note, it's in the supplementary bundle at page 53, the original set of submissions that the appellant made. And of course, the court will bear in mind that when he prepared his second report, Dr. Pratt had Ms. McGraw's report with the impression management issue raised at that stage as well. Of course, Dr. Pratt is not there to address matters as an advocate, but insofar as there was a question about the impression management issue and expert evidence was going to be assistance on that, then that opportunity was there and in fact was taken up. Also, the court, again, just purely for the note, in the appellant's own submissions from November 2020, again, it's a matter, or these issues about impression management are addressed, and for your note, again, that's at pages 92 to 93 of the supplementary bundle. So we'll come on to, in due course, of course, to the value of an oral hearing, which is the principal issue in my respectful submission in this case. But insofar as it's material, those points could and indeed were be raised by way of submission and indeed expert evidence, addressing them in advance of the LAP recommendation and, of course, the decision that's challenged. Another point which is made by my learned friend relates to the contents and the tenor of Ms. McGraw's report and the conditionality of some of the conclusions. He clarified in his submissions that that's not a criticism of the report, and I'm grateful for that clarification. My Lady Justice Elisabeth Laing, I think, in the course of intervention, suggested that the report need not be in any way weak or inadequate as a result of conditional or careful analyses, and I respectfully agree with that observation. Seen in its context, the conditional recommendations in my respectful submission are characteristic of a careful and nuanced approach to the case, rather tending to undermine the need for further exploration than to support it. Final point the learned friend raised is in relation to the negative associations issue. And again, this is a point which could and indeed was addressed in the course of submissions prior to the LAP recommendation, and again that's at page 53 of the supplementary bundle for the court's note.
I'm so sorry I missed the page reference.
It's page 53 of the supplementary
Thank you
bundle.
very much.
And indeed, pages 53 and 54 of the supplementary bundle, the submissions which were filed on behalf of the appellant by his solicitors deal in some detail, as the court will no doubt have seen, with the disputes insofar as they exist between the experts, and makes clear what the appellant's position is on those disputes. So in my respectful submission, the identification of issues which might potentially represent differences between experts, or indeed matters which the appellant wished to raise in objecting to the contents, in particular of Ms. McGraw's report, doesn't, bearing in mind the particular process which is adopted in the recategorisation procedure, doesn't in fact make out a case for an oral hearing, but rather tends to support the contention or the idea that the procedure looked at in the round is capable of, and does indeed in fact capture, the appellant's own submissions, position and evidence. And that's a point which the court will have identified, in particular in paragraph 51 of the Hassett decision, is highly material in this case. If I may then touch on next on a few matters in general terms, before moving on to the specifics of the grounds. The first point to make, of course, is simply to identify the nature of the decision which the CART director is taking in the course of this process. And the test, as Madame has already referred to, is set out in paragraph 4.2 of the PSI, so the policy. Again, unless it would be of assistance for me to do so, I won't take the court there, but you'll note that's at page 119 of the supplementary bundle, 119.
Yep.
And the test is, the key points are that the evidence must be convincing evidence available to the director, to the CART, I should say, that it shows that convincing evidence must show that the risk of reoffending, if unlawfully at large, has significantly reduced. There are then, as Management has already referred to, some examples of the kinds of evidence which might support that conclusion. But in short, what the CART requires is convincing evidence of a reduction, a significant reduction in a risk of reoffending if unlawfully at large. So in that hypothetical situation, a high standard of evidence is required. And that, of course, feeds into the question of what is required by way of a procedure, a fair procedure. And the second point to make, which follows from that, is again simply to identify the point which Lord Justice Sales, as he was, identified in Hassett, touching on the nature of the CART's task and contrasting it with the parole board's. Again, bearing in mind that the court has read that decision, I'm sure it's not necessary for me to take the court to it, unless that will be of assistance, but simply to identify that paragraph 51, in particular Roman 2, there is particular guidance on that, and that the thrust of that, the thrust of the conclusion from Lord Justice Sales is to identify that this is an administrative process, and that the final decision, the subject of the challenge here, the 19th of January decision, is in fact simply the terminus of a long evidence gathering process. Perhaps a slightly unusual process for administrative decision making, the court might think, where a wide variety of professionals involved in the care and administration, care and discipline of a prisoner feed into a process that then ends in a decision. Ladies, my lord, it is in that context then that consideration must be given to the appropriate process and procedure to be adopted in general terms, and focusing in particular on the oral hearing question. I'm mindful of the time and I'm about to come on to the question of the submissions prior to the LAP recommendation. I'm of course in the court's hands, but it may be convenient to pause at this moment and then to pick up after that.
Certainly.
Thank you.
I think we're not pressed for time, are we?
I don't believe so.
In that case, 2 o'clock.
Court rise table.